Hello everyone, this is Sakshi. I hope you're all doing great, and I welcome you to the very first session of All That Is Law. So, our today's topic for discussion is arbitration. Now, as we are all acquainted with how courts proceed, how courts function, courts being the traditional legal institution for the adjudication of any disputes. Similarly, litigation being the most traditional means of adjudication of referencing a dispute. What is arbitration? What is the process of arbitration? How the process of arbitration is different from litigation in general. Who is an arbitrator? What is an arbitration institution? We would learn this all along. So, in order to learn about any concept in general, we are required to dive into its depths. Then only we will be able to navigate the intricacies of any concept in general. So, what are we waiting for? Let's proceed towards the introduction of arbitration itself. Arbitration being an ADR mechanism, that is alternate dispute resolution mechanism, it is wherein third party is appointed for the resolution of dispute. Person being an arbitrator, arbitral tribunal being an institution, and the same passes an arbitral award, which is judicial decision of the arbitral proceedings. Mind you, this arbitral award has enforceability, that it is binding on the parties submitting the dispute for arbitration. Now, the judicial instance of arbitration can be traced to Section 89 of Code of Civil Procedure 1908, which provides settlement of disputes outside the court. Subsection 1 of Section 89 provides, where the court is of the opinion that there exist certain elements that a settlement is compatible between the parties, then the court shall formulate the terms of settlement and give it to the parties for their observations. After receiving observations from the parties, it shall again reformulate the terms of settlement for arbitration, for conciliation, for judicial settlement through lok adalat, and mediation. Now, subsection 2 of Section 89 provides where a dispute has already been referred, the provisions in case of arbitration, the provisions of Arbitration and Conciliation Act of 1996 shall apply. In case of lok adalat, it shall be in accordance with subsection 1 of Section 20 of Legal Services Authorities Act of 1987. In case of judicial settlement through lok adalat, the court shall refer the same to a person or an arbitral institution. The court shall refer the same to a person or an institution in general, who shall be deemed to be as a lok adalat in accordance with the provisions of Legal Services Authorities Act of 1987. And in case of mediation, the court shall effectuate a compromise between the parties, and the same procedure shall be followed therein. Now, after understanding the judicial instance and the process of arbitration itself, let's move on towards the historical position of arbitration in general. Now, the process of arbitration has evolved through generations. The same can be traced back to the very first instance. Speaking as of the colonial era, the Bengal Regulation Act of 1772 had an instance of arbitration. Of course, this Bengal Regulation Act of 1772 itself has gone through several amendments. The 1781 amendment, the 1787 amendment, the 1793, the 1795 amendment. Yes. Speaking of the Bengal Regulation Amendment of 1802, 1814 and 1833 is very important concerning it proposed certain changes in the procedural law of arbitration itself. After that, the Legislative Council came into existence in 1834 and the Code of Civil Procedure 1859. Correct, 1859. Now, this Code of Civil Procedure 1859 was concerned with the governance of civil proceedings, but that itself went through several amendments, several evolution itself. The Code of Civil Procedure of after 1859, it was 1877 and 1879, and finally the Arbitration Act of 1899 came into existence. This was based on the English Arbitration Act of 1899. After that, the Legislative Council enacted the Indian Arbitration Act of 1940. Now, the Indian Arbitration Act of 1940 dealt with domestic arbitration only in general. Of course, it had applicability throughout India except Jammu and Kashmir at that particular point of time, before the Jammu and Kashmir reorganization, of course. but it lacked on the concept of international arbitration. Also, it lacked enforceability in terms about the finality of arbitral award. So it was left to the scrutiny of the courts. So then, the Arbitration and the Conciliation Act of 1996 came into existence. Now, this Arbitration and Conciliation Act of 1996 is based upon the UNCITRAL model of United Nations. Of course, it covers both domestic arbitration as well as international arbitration in general. It deals with various aspects of arbitration concerned. Now, concerning the present amendments of 2015 and 2019, but the 1996 is a blanket legislation which covers each and every aspect, each and every intricacy of arbitration in general. That is the Arbitration and the Conciliation Act of 1996 in various aspects. We would discuss this in the upcoming videos, of course. Now, speaking of this in the British era, but what was the position in the Hindu law? In Hindu law, arbitration was present too. And where do you find the instance of the same? Through the Vedic treatise of Brihadaranyaka Upanishad, which was in 7th to 8th century BCE, which was based on, basically it is a human passage which concerns about Atman, and various aspects of human life. It proposed the idea, the notion of arbitration for the very first time. It is interesting. The words that you can find in the treatise are Puga, Shreni, Kulas. Puga being the local courts, Shrenis being the people belonging to the same profession, and Kula being the person of the same community. This all being the panchayats, that is the arbitral tribunal, the person, the institution presiding over the dispute. So, of course, at that particular point of time as well, arbitration was considered as an private dispute resolution mechanism. We have seen its evolution, we have seen what arbitration is all about, and we would see more about how arbitration as a process has advantaged parties, how it is used in day-to-day life, and the provisional applicability of arbitration in today's life concerned in the upcoming videos. Now, if you liked my video, please like, subscribe and comment, of course. And if you like such content, please let me know. I would post similar videos in the upcoming future as well, because we are all learners at the end of the day, and not just you, me too. So keep learning, keep growing. Thank you.